SJC-13747, Commonwealth of Massachusetts versus Meta Platforms, Inc. et al.
Attorney Mosier.
Good morning, Your Honors. May it please the court. This lawsuit would impose liability on Meta for performing traditional publishing functions. Section 230 of the Communications Decency Act and the First Amendment prevent that result. The Commonwealth argues that its claims do not depend on third-party content, but the allegations in the complaint tell a different story. The complaint alleges that teens will stay on Instagram longer and view more videos, photos, and messages when they find the content engaging, and that they'll stop viewing content when they get bored. The Commonwealth's theory that teens spend too much time on Instagram necessarily depends on third-party content.
Is that the test?
The test under Section 230 is whether Meta would be held liable as the publisher of content of another.
And you're saying that once a claim depends on content, you are being held liable, your client's being held liable for being a publisher.
If they're engaged in traditional publishing functions, that's what this court said in Turo, and that's what federal courts of appeals have said. And so then the question is whether this claim would impose liability on Meta for engaging in traditional publishing functions.
Okay, so it's more nuanced than just it depends on some content.
So courts, including this one, have stated the Section 230 test to have three elements. One of the elements, the first one isn't contested here, which is that Meta is an interactive computer service. And so really the issue are elements 2 and 3. One is whether the content at issue is third-party content versus Meta's own speech. There's no allegation that any of the content that the teens are viewing is Meta's own speech. So it is content posted by other users. Then the additional element.
So just to put a fine point on it, the notifications that are being pushed to users' screens, right? Sorry. That you're saying that is third-party content?
We're saying that has third-party content because as the complaint alleges, what the notification is informing the person of is that another user liked their post, commented on their post, sent them a message, and so it is providing information to
Is there a difference between telling a user that a message has been sent to them versus relaying the message?
It's providing the information in a different format, but it's still the same information.
It's not the third party that's telling the user, hey, I've messaged you, right?
But what the information says is that the person messaged you. So it's just another.
Right, and who creates that content?
I mean, Meta provides the notification, but I guess I
guess I'm wondering why, at least with regard to that notification design feature, this is covered by Section 230.
So what the district court in the Northern District of California held that oversees the MDL, it says to the extent that notifications relay third-party content and involve third-party content, then they're barred by Section 230. But when a notification has first-party content, if it is Meta's own speech in the notification, that might bring it out of Section 230, but that clearly brings it in violation of the First Amendment. There's no allegation that any of this speech or any of the information in a notification is false or misleading. If the information says a particular user sent you a message, and if that is truthful,
I didn't understand the claims to be that Meta is relaying false information vis-a-vis the notifications, but that it has created an algorithm of incessant notifications. So much so, designed so as to feed into the fear of missing out, FOMO, that teenagers generally have.
Correct. So
that's the basis of the claim.
But what that basis of the claim, though, is, I think it's important to understand what they're saying they're missing out on, what they're saying they're doing too much of on Instagram, which is viewing third-party content, engaging in speech, viewing speech of others, messaging with others. The Commonwealth is very clear that the features that they are challenging are features that they allege lead to teens using Instagram for more time, for viewing more posts. And the reason that the Commonwealth doesn't want Instagram to use those features is to achieve a goal of reducing the amount of speech on the platform, reducing the amount of videos shown. And so what this court said in Turo—
Well, I didn't just sort of viewed in the light most favorable to the complaint. I thought the motivation of the Commonwealth was to protect against psychological harm that is being bestowed upon teenagers as a result of these algorithms that get them hooked on it, for lack of a better word.
That's true, but what the allegations are is that they are hooked on viewing more content. And so it's really not much different than the theory that the Supreme Court had before it in the Brown case, which involved the violent video games and California's attempt to regulate teens' access to violent video games. There, what the legislature found is that when children play violent video games, they become more aggressive and they act out more. And so the state had psychological studies to show psychological effects of playing video games. But what the Supreme Court said, that law was still—
Sorry, go.
I was just going to say that even though the state said that it was attempting to regulate and prohibit speech for the purpose of protecting psychological harms to teens, it still applied a strict scrutiny First Amendment analysis and said
Okay,
it
so
applied here.
you're moved on to the First Amendment. It's just sort of sticking with 230, though. I'm wondering how the notifications themselves violate or are covered by 230 in terms of treating Meta as a publisher of third-party content, given that the third party isn't actually creating the content that you're pushing to the kids.
So what the Ninth Circuit said in Dyaroff, which is a case that this court cited in Turo, is that Section 230 bars challenges to notifications, because what the notification does is to facilitate communications between users. It informs the user that there is new and additional third-party content on the site. And for that reason, you are publishing the information to the user that there is third-party content that they may be interested in seeing. And so that's why courts have said that notifications are barred by Section 230. But as I said, if—
In your view, is there any notification that would fall outside the protection of Section 230?
So if the information in the notification was, from Meta, about Meta, and said there's a new update of Instagram that you should go to the App Store, something like that, that would be not barred by Section 230, but certainly be protected by the First Amendment.
What about if the notification says, today's a good day to check your Instagram?
I think that you could view that as meta speech, but that would be protected by the First Amendment.
But I'm only asking about 230 because as far as I understand it, 230 is the only issue that we've agreed to take. So that would fall outside 230?
So for 230, the liability—
So what difference does it make if Meta says, check your Instagram, someone liked you? Because no user said someone liked you, right? Or someone liked someone else. This is the message that Meta created. So what's the difference that would suddenly put that message, that notification, within the ambit of 230 and the other one outside?
So the message that is created is a message created by one user to another. And that message is that I like your post. When you are inside the app, Meta has made a publishing decision to format and display that message to a user by showing a heart that changes colors with the person's name on it.
But this is when the person's not in the app, right? So it seems to me that you have the like, someone does a like, I don't know because I don't use these things, but someone does a like and likes another post, and Meta has nothing to do with that. Someone's just doing it. That original like is, let's assume, within the protection of Section 230. Then Meta decides to retransmit that to someone who's not using the app, maybe a subscriber, but is not using the app. Why isn't that decision to retransmit not protected? The user didn't make that decision. A user of Meta did not make that decision. Meta made the decision.
So my point was where I was going with the explaining the heart. It's the same information. It's just a different way to format it inside the app.
Okay, but there's an action there that is not user driven. There's an action by the corporation that is not driven by the user. Can we agree at least on that?
Yes, but
Okay.
and the question is whether that action is a publishing function. And so the act of publishing the information that another person liked your post, that's a publishing activity that informs the person of third-party content. You could compare it to a magazine. So you have all of the articles inside the magazine, but people may not know what's in the magazine, whether to pick it up. So what you do with a magazine, you have a cover. You have a cover that might have a summary, a description of the articles that are inside the magazine. That's a publishing decision.
I think of it
Use a
more
cover.
I think of it as being more analogous to advertising, not publishing. So you have a magazine publisher is publishing the magazine, makes decisions about where to put them in the layout of the magazine, what to give, what size font to use, et cetera, et cetera, et cetera, publishing decisions. But then the magazine publisher decides to run an ad on television or send mail to people, U.S. good old-fashioned postcards, and says, subscribe to our magazine. This is the kind of thing that's in it. That would not historically have been thought of as a publishing act, but rather as advertising. And this seems to me much closer, these notifications seem to me much closer to that.
Well, the reason I think they aren't is the information that's being conveyed, and this is what the state alleges is the information that draws the person back into the app, is the third-party information. I mean, maybe a hypothetical could work and show why the third-party information is what matters. If you get a notification that says your math teacher posted today's video of the lecture, you may not be inclined to click on it. If you have a notification that says Taylor Swift liked your post, you're going to be more inclined to click on it. So what the third-party activity is that happened on Instagram is what affects whether or not somebody engages in the content.
Same thing for advertising.
Correct, but it shows
Right?
the
You
content
may
matter.
not, you may not want to advertise the, article on whatever people find boring, and then advertise the article that you think will increase the subscription to your magazine. But I don't know that that's publishing
So
as opposed to advertising.
I think advertising can involve publishing, but I think this issue of between whether it's first-party speech or third-party speech, I don't understand the Commonwealth to say that they think this is Meta's own speech, because the issue
They
is
say that it's conduct.
correct. The conduct, the providing the notification is conduct, but I think the important thing under section.
The decision to send notifications, and particularly at this frequency in this manner, is conduct, not a publishing activity.
So they say it's conduct for purposes of Section 230 and for the First Amendment. The question is, what is the nature of the conduct? If the conduct is publishing activity, then it's protected by Section 230 in the First Amendment. But where I was going, I guess I want to respond to one point
Can
Your
you
Honor
address
made.
the advertising? Is your view that this is publishing, not advertising? I mean, this advertising publishing distinction, I'm not sure I follow yet. So when, and again, I'm not on Instagram, so when this pops up, I take it it's got some kind of, it contains the content as well as when it pops up, it has both, right? It has both the content and the like feature or the scroll feature or the it's going to disappear feature.
No, those are separate features. The notification, it will just include a line that says, user ABC liked your post, commented your post. So it's just a way to give you information about the third-party activity that's happening on the platform.
So how is that publishing the third party, or is Justice Wojcik right? It's severable.
The information that's contained in the notification is the information about the third-party content that has been shared on Instagram. And so that's what the Ninth Circuit said in Dyaroff, when it said that notifications are protected by Section 230. It says notifications are a way to inform and to facilitate communication between users by telling users that there's new content on the site. And that's why I think it's analogous to the cover of a magazine, where you put in shorter, abbreviated form.
I understand you say you're either going to be in the First Amendment publishing, your advertising is publishing under the it's Meta or Instagram publishing, right? There's no gap for you. You're either protected by the First Amendment because you're publishing your own information, or you're publishing someone else's information and you're covered by 230, right? That's your argument today, right?
Yes, that's correct. And there's no allegation, there's been a lot of discussion about advertising, but there's no allegation about any challenge to advertising, or there any advertising at issue.
We have arguments from this moderator's dilemma that 230 is limited only to publishing or moderating the content of the publication. I don't know if that's right, but that's an argument that says there is a gap somewhere. There's something in between, right?
That's not the position that federal courts of appeals have applied, and what this court
Well, I thought that whole brief came from the Ninth Circuit. So how can you say it didn't? Is that brief just wrong? The Ninth Circuit doesn't have this moderator's dilemma approach to whether the claim treats the Metas of the world as published.
The Ninth Circuit doesn't describe their test as a moderator's dilemma. How the Ninth Circuit. Correct. The question is whether you are engaged in traditional publishing functions. And what this court said in Turo, relying on the First Circuit's decision in Backpage, is that traditional publishing functions include not only the decision of what to publish, but how to publish it, in what form to publish it. The Supreme Court in Moody, addressing the First Amendment, made this very same point.
Let's just stick with 230.
Okay.
Yeah.
I mean, one way to look at this and the difference in why.
So that's what I'm trying to figure out. Is there a third category, even if you don't buy into so there's publishing, there's moderating publishing, and now we've got this third thing where you're putting out your own information about the published information. And I understand you say that's covered by the First Amendment, but we may not even have to get to the First Amendment because you're here on interlocutory appeal. So why is that third category protected if it's not published information, it's not moderating published information? Why is it covered by 230? It's what?
So all of the categories you laid out, I would say, involve publishing activity. Moderating content involves publishing activity. But for purpose of Section 230, the two elements that we're focused on is the action and the activity that Meta is engaged in has to be publishing, and what it has to be publishing is third-party content.
I thought you agreed with Justice Wojcik that these additional sort of like features and scrolling stuff that's going to disappear on you is not publishing.
No, I'm sorry if I gave that impression. Not at all. Let's talk about the ephemeral content. I think that is the clearest and most obvious feature that they challenge that is clearly published, clearly barred by Section 230. What they are saying is that Meta should be held liable for removing some content after 24 hours. They're saying the decision to take content off of Instagram is unlawful. It is, if there's anything that courts can agree is barred by Section 230, is that you can't be held liable for either publishing content or removing.
So if the disappearing feature to you fits in with the moderating content protection.
It's removal, right? They're saying you're going to be held liable for removing content before we want you to. We think you should publish certain content where they don't say how long, whether it's 48 hours or for a week, but they want to hold Meta liable for removing content
So
after
even if-
24
What
hours.
does that algorithm look like? And I don't mean the code. I mean, do users get notified, like you got 24 hours to see this, or like how does that work? Is it like Snapchat? I just don't.
So there are different ways in which content can be posted and presented. So the content in your feed doesn't disappear after 24 hours, but you can have
So
stories and roles like across the top. Those will be on for 24 hours. So it's a different part on the screen, the particular types of ways that you post the information will go after 24 hours. And so what the Commonwealth wants to do is to say those posts need to stay on for longer than 24 hours. And every court that has looked at a claim that said you're going to be liable for removing content has said that's barred by Section 230, because in some parts that was the conduct that led to the adoption of Section 230, is you shouldn't be held liable for removing content or publishing content. If we look at some of the other features that they challenge, infinite scroll, there what the theory is that when you scroll, just by the act of scrolling on your screen, additional content is published, new posts come up. And if the structure and the format of Instagram has changed so that after you scroll for a bit, you have to click a button to get additional posts, their theory is that people may not click the button. And so the result is they're going to view less content. So the very reason that they want to challenge infinite scroll is they think that by making it easier to access content, you're going to consume more content. They want to discourage teens from staying on Instagram and viewing more content. And so they want to change and require a click to see more content. So the fact that the feature they're challenging, and the reason they're challenging it, is they want to make it harder to access content for the purpose of trying to discourage content, I think demonstrates that this is
Well,
involved.
I don't know if they're saying that the purpose is to discourage content. The purpose, as I read the complaint, was to not hook the teenager to stay on the phone and continue to get content indefinitely.
What they allege is what they call passive consumption, that if videos will play automatically and additional posts will pop up automatically. You're
Right,
gonna
so they're
consume
going
more.
after the design feature of having this autoplay. Your reading of that is that they're trying to insert a button so that that's the remedy that they're looking for. I guess I'm wondering if there's a difference between policing content and policing an algorithm that is designed to keep teenagers on the device
So
or the
but
app.
again, but that what you call the algorithm, they call a design feature, is a choice about how to publish the information. I know.
It's not how to publish, it's how to attract you to the information, right? It's how to attract the eyeballs. It's indifferent to content, right? It doesn't care if it's Thomas Paine's common sense or nonsense. It's totally focused on just getting you to look at it. It doesn't care what it is.
But courts have made clear that how to present content is part of the publishing function. Think about comic books. And right in the 50s, the legislatures were concerned that teens were spending too much time reading comic books. If you passed a law and said comic books need to be published in black and white because we think the fact that they're color or make them more engaging, make teens read comic books more, so we're going to require you to publish them in black and white, and the reason is that we think people are going to read less of them. Of course, that would be a First Amendment issue, and I think
Would it violate 230?
It would, because it is a publishing function to decide how to publish. And I think the First Amendment is before the court because it can decide non-immunity issues. But even if it's not, I want to point to a part of Moody that I think is equally applicable to the First Amendment and to Section 230. And what Moody said is that a social media company's decisions not only about what content to put on its app, but how to display content is a traditional publishing function.
Moody's is it's hard to figure because they're talking about curating content in Moody's, right? I mean, are we really dealing with curating content? Or are we dealing with Justice Barrett talked about, just as a logarithm that stimulates looking? And I mean, she suggested that might not even be covered by the First Amendment, right? Is this all driven by a logarithm? It's not like we got people trying to figure this out. We've got some kind of, is it a logarithm we're dealing with?
So a couple points. First, they don't challenge the recommendation algorithm, but I think it is clear that Meta's recommendation algorithm is covered under the First Amendment under Moody, because the Supreme Court had two, and the evidence before it had two algorithms that it was considering. And one was the Facebook news feed. And so it looked at Meta's algorithm of how it provided a news feed on Facebook and said, based on the record before us, we can tell that this is covered by the First Amendment because Meta makes choices about what content to display, how to display it, what content it's going to moderate and not allow on the feed. That was Facebook. This was Instagram, but they're both run by Meta. There's no allegation that somehow Instagram works differently than the Meta. What Justice Barrett in footnote 5 of the majority opinion was leaving open is whether there'd be First Amendment protection for a feed or an algorithm that didn't reflect editorial judgments by the person. Go ahead.
I'm sorry, can you address why you're here? Your right to be here.
Sure.
In our doctrine, present execution.
Yes. Yeah. So under the present execution doctrine, the court has recognized that if you've been denied an immunity from suit, you can take an immediate appeal. In the Lynch case, the court looked to the Federal Volunteers Protection Act, and there it said the volunteers may not be held liable for certain acts. And it said the fact that it just says no liability and doesn't say immunity is not dispositive. We're going to look to the purpose of the statute. And when the court looked at the purpose of the statute, it determined there was an immunity from suit. Here under Section 230, the language goes well beyond the Volunteer Protection Act that was at issue in Lynch. What the statute here in Section 230E3 says, no cause of action may be brought and no liability may be imposed. That language, no cause of action may be brought, says you can't file a lawsuit to challenge protected content. So that refers to C1, which says that no provider can be treated as a publisher. So the language in E3 says no cause of action may be brought. That's best read as an immunity from suit. A number of federal courts of appeals have read it that way. The Texas Supreme Court in In Re Facebook probably has the most extensive discussion and textual analysis of why Section 230E3 creates an immunity from suit. But we think the language in E3 is much stronger and clearer than the language that the court found sufficient to satisfy the present execution doctrine in Lynch.
So if we accept that, why shouldn't we stop there and not get into the First Amendment? Particularly, I mean, Moody's is not very clear. Why should we go beyond just pining on 230?
So in a number of cases, including the Kent decision, the court has recognized when it has an appeal under the present execution doctrine, it can reach both immunity and non-immunity issues. I think it makes sense to address Section 230 and the First Amendment together because of the way they complement each other and the way they overlap and these difficult questions of, let's go back to notifications, right? And I'm going to refer again to what the federal district court judge overseeing the MDL held. It said, if you look at a notification as containing third-party content, it's barred by Section 230. If the notification contains first-party content, the claim's barred by the First Amendment. And so I think you would kind of artificially limit.
Is there any room for expressive speech or in the First Amendment context? Like, why is that expressive?
It is expressing actions, right? I mean, we think it's best viewed.
It's conveying information, that's true. But is that enough?
If factual, truthful information, absolutely, right? You can't be held liable for stating a truth.
But I don't see, again, I mean, I think the Commonwealth claims is not that the notifications are inaccurate in any way.
And
that they're incessant.
Correct.
The volume of them, and when you're no longer using the app, is driving the kids back to use the app.
Correct. And it would, I think the Commonwealth would have a better chance of getting around the First Amendment if they alleged that the speech was false or fraudulent. But when they acknowledge that it's truthful, that brings it in the heart of the First Amendment. And then the fact the number of
So
number of
there's
claims.
no, so the First Amendment protects against serially calling somebody at home to let them know that, you know, Bobby is friending me or liking my post. Like just every 5 seconds, phone call after, there's nothing, the First Amendment cannot allow that or protects that?
So first of all, the First Amendment, the starting point is the First Amendment is clearly implicated, and what the Superior Court held here is that the First Amendment was not implicated. What you can do in many circumstances consistent with the First Amendment is regulate speech based on time, place, and manner if you satisfy intermediate scrutiny. Here, there's a couple problems with that. They want to go to a jury on a 93A claim and just ask the jury, is the structure of Instagram fair or is it unfair? That's not the type of inquiry that you could use to make a determination regarding any level of like heightened scrutiny. So even time, place, and manner restrictions require heightened scrutiny. What the Supreme Court has said in cases like Brown and O'Brien, to satisfy intermediate scrutiny, a state has to show an interest that is unrelated to the suppression of speech. Here, that the reason that they want to change these features is so that teens will use Instagram less, will consume less speech, will engage in less speech. The interest is not separate from suppressing speech. It is to reduce speech.
You can
in order
bring
to
that
keep
up
people
at the normal time frame. You can argue if we decide 2:30, you can bring your First Amendment defense at, later on in the ordinary course of litigation, right? We don't know. You're asking us to decide a complicated federal constitutional question prematurely and perhaps unnecessarily, aren't you?
So, I mean, I think because the challenge features are barred by Section 230, you can reach that and do that. Why I was saying, I think both the First Amendment question is before the court, and it makes sense to think about them together, is if the reason that you think Section 230 doesn't apply is because the speech at issue is Meta's own speech, which I don't understand the Commonwealth to be arguing, but if the court's view is it's Meta's own speech, I think it's important to recognize that doesn't mean Meta can be held liable for it. It means that it's brought right into the heart of the First Amendment. And so the way that those two defenses interact, I think it makes sense to consider them together, but certainly I'm not suggesting the court is required to, but I think the court can, and I just see benefits in doing so.
Okay,
Thank you.
Attorney Kravitz.
Good morning. Excuse me. May it please the court. David Kravitz for the Commonwealth. With me at council table is Christina Chan.
Mr. Chris, could you address, and I'm sorry to throw something at you quickly without your, I'm sure, practice and introduction. Could you just address present execution before we get into the niceties of 230?
Yes, absolutely. I'm happy to do that. So yes, this appeal in our view should be dismissed. Section 230 confers a limited immunity from liability, but it does not confer immunity from suit.
Well, then why does 230 say that no cause of action may be brought?
Sure. So, and I will concede absolutely that language, read in isolation and divorced of all of the other things that Lynch instructs that we should look at, lends some support to the notion of an immunity from suit. So I agree. They do have that sort of on their side of the ledger, but I think on our side of the ledger of the, first of all, of course, the default rule is that there is no interlocutory appeal. Secondly, the operative part of the statute is Section 230C1, which says that you may not treat companies like Meta as a publisher. That says nothing about the burdens of litigation or about immunity from suit, anything like that. 230C2, the immediately following subsection, talks specifically about protection from liability. A and B, the congressional findings and statements of policy, say nothing about shielding companies from the burdens of litigation. And then if we go to the legislative history, we see that Congress, again, is talking about shielding companies from liability for certain kinds of activity, but they say nothing at all, as far as anyone has been able to detect, about the burdens of
in
litigation and
E3,
litigation costs.
except in E3, where there's
so-
no way to vindicate that right, that no cause of action may be brought other than immediately, because once once you go through trial, the cause of action has been brought.
Yeah, no, so again, I mean, I don't disagree that language is supportive of that position. My point is that Lynch itself, I think, is really instructive here, because in Lynch, the statute talked only about liability. And so that's what the plaintiff's argument was in Lynch. The plaintiff said, well, the statute says liability, so that should be the end of the inquiry. It's an immunity from liability. And this court went beyond the language of the statute and looked at the overall policy and the overall inquiry into what it thought the legislature was doing. And having found specific mention of concern about imposing the burdens of litigation on volunteers who were serving on nonprofit boards, that the court was persuaded was enough to get you into immunity from suit. But here, there is nothing like that. There's no reason to think that Congress was trying to shield companies like Meta from the burdens of litigation. I would also, sorry, go ahead.
They talk about other, I mean, smaller, not everyone's Meta, but.
No, for sure.
And the possibility of basically being sued for all the content you provide. So it seemed like it seems like they were concerned about the litigation, sort of unlimited litigation that would result if you're going to hold, them responsible for everything published on the sites, right?
So they were certainly concerned about liability. There's no question about that, and that's the whole purpose of Section 230.
The morass of litigation that would ensue here too, right?
I mean, I didn't see anything in the legislative history that talks specifically about the burden of litigation and the cost of litigation. But that leads to an additional reason.
Are there any cases where you have this no cause of action language and they still found you couldn't bring in an interlocutory appeal?
Oh, for sure. So the 10th Circuit has squarely held that there is no interlocutory appeal under Section 230, and they look at Section 230E3 and I think correctly conclude that that is a preemption provision, because 230E as a whole, it has 5 subsections. It is entitled Effect on Other Laws. And that's the whole purpose of Section 230E, is to go through when it does and does not, how it does and does not interact with other laws. So 230E3 simply tells us which state laws may be enforced and which state laws may not be enforced. So that, I think, so that's the 10th Circuit's take.
Pivot to the unfairness claims, counts 1 and 3. Why are those not treating Meta as a publisher?
Sure, I'm happy to discuss that. So as to the unfairness claim, first of all, just to preface it, the deception claims are completely outside of Section 230 because those are based on Meta's own speech, and therefore they would continue regardless of what happens with 230. So the key to this whole thing, what does it mean to treat?
Meaning Zuckerberg's comments that they're not trying to entice kids onto. That's what you're talking about.
The deception, yes.
Not the deception on the websites, but the deception by the leadership of Meta, right?
Correct. Okay. Correct. Yeah, as sort of alleged in detail in the complaint. So as to unfairness, the key to this whole thing is, what does it mean to treat a company as a publisher? Because that's what 230C1 says. And that goes back to common law publisher liability. And that was the whole genesis of Section 230 in the first place, where in the Stratton-Oakmont case in New York, somebody published defamatory material, allegedly defamatory material, on a website. And the court said, okay, website, under the common law, you can be held liable to the same extent as the original tortfeasor. So that's common law publisher liability. Congress got wind of that decision, concluded that it was going to be a real problem for developing the internet, and so it wrote Section 230, which says you may not treat a company, an online company, as a publisher of third-party content. But what that means is that you may not hold a company liable for harm caused by the third-party content. So that explains all of these cases.
Well, but that's where I get lost a little bit. So they're super publishing, and that may be the wrong word, but they're basically taking the content. They don't care what it is, and they're just making everyone look at it. They're like the greatest publisher on earth. No matter what it is, they found a way to connect someone who's interested in this, and they're making you look at it and they're getting you excited about it. Isn't turbocharging part of publishing? You know, turbocharging interest in that? That's where I get lost a little.
Yeah, sure. So let me answer it this way. There's a critical and legally really important distinction between engaging in publication activity and being treated as a publisher. Because being treated as a publisher, which is the language of 230, that is what is talking about the old common law rule of publisher liability that Congress clearly was intending to overrule in this context. Engaging in publication activity is completely different. I mean, all of these websites, Meta and all of the websites in these other cases as well.
Why is it completely different? I don't understand. Why is it, you're drawing a distinction between engaging in publishing activity and publishing. What is the difference?
No, excuse me. I'm drawing a distinction between engaging in publication activity, which is, all of these websites publish third-party content all the time. There's no doubt about that. But being treated as a publisher has a very specific meaning that comes from the common law. And the Henderson decision in the Fourth Circuit is very helpful on this. Jones in the Sixth Circuit also talks about this. The Superior Court noted this in a footnote in its decision, saying the purpose of Section 230 was to overrule common law publisher liability for websites like Meta. And so the difference is, and this sort of goes to the question of the but-for test. Meta's basic argument is that without videos, there would be no autoplay. In other words, if 30 parties were not posting videos, there would be no autoplay. If they weren't posting photographs, there would be no infinite scroll and so on. And so you wouldn't have any harm of the kind that you're alleging without the third-party content. Therefore, you must be treating us as the publisher, and therefore 230 applies. That's wrong. What they are trying to make is this but-for argument. But for the content, you wouldn't have harm, therefore we're immune. That argument has been considered and rejected, very clearly rejected by Henderson in the Fourth Circuit, by Internet Brands in the Ninth Circuit, and by this court in Turo.
But to be fair, I thought the argument was not, everything we do is publishing, so you can't touch us. It's more these things, the notifications, the ephemeral content, those are the kinds of things that traditional common law publishers engaged in. And we're just doing it better on a more mobile platform.
I think that is their argument, but it's wrong for the same reason I was saying earlier, because that does not, even if we hold you liable for that, that does not mean that we are treating you as a publisher.
But why?
Why? Because treating as a publisher has a very specific meaning that goes back to the common law. Are you holding the defendant liable for the harm traceable to the third party? So in Lycos, defamation, Backpage, sex trafficking, force, terrorism, Dyroff, drug dealing, estate of bride, harassing and bullying content. All of the harms in those cases can ultimately be traced to what the Ziran case in the Fourth Circuit calls the original culpable party. That's a really useful construct because it explains all of these cases. There is no original culpable party here.
Like in a book, the author is the person who wrote the book, right? But the publisher, D.H. Lawrence writes Lady Chatterley's Lover. But the publisher puts out a book with a sexy cover on it that people want to look at. The publisher and that's why they read the book, and that's why they're exposed to this. Or is that not publishing? I'm confused by that. When they put that fancy cover that makes people want to read it, that's not publishing?
It is publishing. I'm not saying it's not.
But isn't that what they're doing here? That seems to be what they're doing. I mean, again, I'm having trouble seeing why they're not accentuating the content in it and getting you all excited about it. And that just seems like what a publisher does. But I just may be missing it.
It is, well, let me put it this way. It is something that publishers do. But again, the words treated as a publisher, it's a term of art. In other words, it's not just sort of the ordinary dictionary understanding.
But when they prosecuted Lady Chatterley's Lover, right, they're prosecuting the people who put out the books, not D.H. Lawrence, right?
I mean, I don't know the history of that case, but I'll take your word for it, sure.
Yeah, okay. And Why isn't that like what's going on here?
So just to be clear about what's going on here, we are not trying to hold Meta liable for any harm traceable to the people who are posting videos of their dogs jumping into piles of leaves. Those are entertaining videos. There's nothing wrong with those videos. And this is not a case, just to be very clear, this is not a case where we are saying that Meta has, created a public health crisis of eating disorders because they haven't done enough to keep that kind of content off of the site. That is emphatically not the kind of case that we are bringing here. Our allegation is that Meta has caused harm through its own conduct and its own choices about how to design the platform to create addiction to, for example, to dopamine hits.
Okay,
There
but
is
so
science that backs this.
let's do the evaporating material provision. Is that not like removing content? Why is that not removing content, which is sort of a core part of 230? That's what because Congress wanted to make sure you could remove marginal content. They're doing it for different reasons. They're removing it so that you read it, which is different. But it's still removing content, isn't it?
It is removing content, of course, but what you just said is exactly why it's different, because they're doing it for a different reason. If they're doing it because it's offensive, because it's content moderation, then what you're talking about is a claim that is potentially trying to hold the company liable for what the third party has put on the site. In other words, they remove it because they think it's harmful. That's content moderation. That's the moderator's dilemma. That's the Moody case. That gets into all of this stuff that we are not, that is not implicated here. Because when they remove content after 24 hours, it's not based on the content. They do it regardless of what the content is. Maybe it's great content, maybe it's terrible content, it doesn't matter. And that's the whole point of our claims. They are independent of the third-party content.
But the removal under 230 was also independent of content. It was designed to protect removing of anything, right? They wanted to avoid getting into the subjective motivation and the politics, right? So they just said, we're going to protect you from removing content. We're going to protect you from moderating content, whether you're moderating it from the left or the right or...
No, absolutely. If you are making, in other words, if the companies are making decisions about the content based on the content of, to sort of use a peculiar construct, but this came up in the Superior Court. If you're making decisions based on the content of the content, as it were, then that is protected activity. That's the kind of content moderation that Congress wasn't trying to encourage. I mean, the whole point of 230 is to try to make it easier, ironically perhaps, to protect children from harmful content on the internet. That's what the genesis of Section 230 was. And so it has nothing to say about the tools that are built into a website to encourage a sort of a biochemical addiction to dopamine content, to dopamine hits, based on the frequency of notifications that are sent to a user's device. Those are independent of third-party content. Those decisions do not depend on what the third parties are posting. And the harm that we're alleging is not traceable to the content of what third parties are posting. And so the Vermont Superior Court put it in this sort of very memorable...
They're taking the content and matching it to your interests, right?
So that is a complete, yes, they are, but that is a completely different argument. That is the algorithm. That's part of what was at issue in Moody. Mm-hmm. The algorithm is what decides which content to serve up to you and in what order and so forth. We are not making any claim about the algorithm. We are not making any claim about alleged failure to moderate content sufficiently or anything like that. Because that would be that would certainly be more close to a 230 problem, potentially to a First Amendment problem. Mm-hmm. We are not making any of those claims in this case. We are making claims based only on the tools that Meta has developed, because its own research shows that they encourage addiction to the platform in a variety of ways that's laid out in sort of excruciating detail in the complaint.
Nobody wants any more questions? Okay.
Okay, thank you very much.